Hi students, in the last video, we have covered two questions of acceptance, which is definition of acceptance and relationship between acceptance and offer. In this video, we will be covering the legal rules regarding a valid acceptance or essentials of acceptance. So there are 7 pointers. Let us go through one by one. The first pointer is the acceptance can be given only by the person to whom offer is made. So if you can recall the case law, Bolton versus Jones, when we are discussing offer. So what happened in this case law? Let us say there are three parties, A, B, and C. A has sold his business to B. A has sold his business to B. Now C, who is the creditor of A, he want to buy some products to settle his liability. So C sent offer to A, but the premises were occupied by B. A has already sold the business to B. So C sends an order to A. However, the order was received by B and B has supplied the material to C. So the offer which was made by C is specifically to Mr. A, not to Mr. B. B cannot supply the goods to C because he is not the valid offeree. Hope it is clear. So acceptance can be given only by A, not by B. So this is the Bolton versus Jones case law. So the A is Brocklehurst, B is Bolton, C is Jones. Jones is the creditor of Brocklehurst. Jones has sent the order to Brocklehurst. Jones is the creditor for Brocklehurst. Brocklehurst sold his business to Bolton. Jones' order was received. Jones' order, which was addressed to Brocklehurst, received by Bolton, and he supplied the material to Jones, which is invalid. So Bolton lost the case and Jones wins the case. Here, the acceptance can be given by Brocklehurst, not by Bolton. So acceptance can be given only by the person to whom offer is made. So Jones has made the offer to Brocklehurst, not to Bolton. C has made offer to A, not to B. This is your first rule. The first rule is acceptance can be given only by the person to whom offer is made. Straightforward legal rule, which you can easily remember. The second rule is acceptance must be absolute and unqualified. When we are discussing kinds of offer, we discussed about counter offer. Counter offer is also called as conditional acceptance. The moment you add any condition, it becomes a counter offer. It becomes a conditional acceptance. Then the conditional acceptance is no more an acceptance. It's a counter offer. Example, A has offered to B to sell his car for 5 lakhs. Now B will ask for installments. Let us say he wants to pay 2,50,000 at one go and 2,50,000 at another go. So he wants to make installment payments. So this installment payment does not considered as acceptance. It is considered as a conditional acceptance. So there should not be any conditions attached to your acceptance. The moment conditions are accepted, it becomes counter offer. It does not becomes acceptance. So the case law which Neil versus Merritt happened to be the same case law. So Neil wants to sell his house to Merritt. So Merritt, he wants to pay the money in installments. He want to pay the money in installments, right? So the moment he gives acceptance with conditions, then it called as counter offer. It will not called as acceptance. So the unqualified means unconditional. So you can read acceptance must be absolute and unconditional. So the second legal rule is acceptance must be absolute and unconditional. Third condition or the third rule is the acceptance must be communicated. The acceptance must be communicated. So in this case law, Brogden versus Metropolitan Railway case law, Brogden was the supplier of coal to Metropolitan Railway Company. So Brogden has issued his offer to Metropolitan Railway Company. they have stamped it or they have mentioned it approved on the letter and they kept it in their table, in their cupboard. That acceptance, that approval was not communicated to Brogdon. Hence, the acceptance was not communicated. There is no valid contract. To become a valid acceptance, it has to be communicated. The third rule is acceptance must be communicated. So let us quickly recap the three rules. First rule is acceptance can be given only by a person to whom it is made. So ABC, we discussed ABC. C has given order to A, only A can accept, only A can reply, only A can accept the order to C, but not B. Second point is acceptance must be absolute and unqualified, unconditional. Unconditional can be the payments, unconditional can be, conditions can be many, right? There can be payments, there can be due dates, there can be quality, there can be product, many things, many conditions can be kept. So your acceptance should be unconditional. If there is a condition, it becomes counter offer, it will not become an acceptance. Third point is the acceptance must be communicated. So you have just written somewhere, but it was not communicated to the offerer. The moment it is communicated to the offerer, then it's a valid acceptance. So quite common sense, all 3 points. Next, we'll move to fourth point and fifth point. Fourth point is with regard to acceptance must be in prescribed mode and specified time. So we need to take an example of government tenders. A government tender, to reply, let us say that we consider it as offer. So to reply to the tender, to provide acceptance to the tender, you need to uh, attach a cancelled check, you need to attach some demand draft to it, and you need to post it within 10 days, within 1 week. Specified time will be given. So any letter which was come to their notice after that due date will not be accepted. Or if you have not attached the cancelled check, if you have not attached the demand drafts to that reply, they will not be considered as acceptance. So at times you need to give the acceptance should be in a prescribed mode and also in a specified time. So it has to be in a prescribed mode and it has to be in specified time. Hope it is clear. Mere silence is not acceptance. The sixth rule is mere silence is not acceptance. So in this case law, Feldhaus versus Bindley, where Feldhaus is the uncle to Bindley. Feldhaus wrote a letter to Bindley saying that I want to buy your house at so and so price. If you are not going to reply within 10 days time, it is deemed acceptance. It is deemed acceptance. Bindley was kept silent throughout the period. He has not given any acceptance. Then Feldhaus, he want to claim that property. So can he claim that property? The answer is absolutely no, because Bindley has never accepted. So mere silence is not acceptance. Any letter which says non-compliance to certain condition or not replying within specified period will be considered as acceptance. The answer is no. So mere silence will never be construed as acceptance. That is your sixth rule. The last rule is acceptance by conduct or implied acceptance. Let us take an example. With an example, we'll understand it better. So A is the customer of B. So A sent a order to B to supply so and so goods within so and so period. If B has supplied the goods within that time, it is deemed acceptance. It is implied acceptance. The acceptance was communicated by way of conduct, by way of action. A has requested to B to supply the materials. That was the offer made. Instead of B replying back that he is agreeing to the terms and conditions, he want to supply the material, what he did is he directly sends the material to A. So the acceptance was communicated through his actions, through his conduct. Then we call it as implied acceptance. These are the 7 rules of valid acceptance or essentials of acceptance. With this, we are done with acceptance. Then we will cover 2 parts, which is communication and revocation of offer and acceptance. So till now we have completed history of contracts, definitions of contract, four important definitions. Then we have moved to contract, two questions with regard to contract. One is with regard to the types of contracts. Second is with regard to essentials of contract, section 10 other than section 10. Then we have discussed offer. We have discussed three questions in offer. Then we have moved to acceptance. We have discussed three questions in acceptance as well. So now there is a joint topic of communication and revocation with regard to offer and acceptance. Let us see communication. Thereafter, we'll move to revocation. Communication of offer and acceptance. Timing. We are discussing about the timing. When the communication of offer is completed, when the communication of acceptance is completed. In case of communication of offer, as offerer himself sends the offer to offeree, promisee, acceptor, so that is a starting point. So there is no communication of offer with the perspective of offer. Whereas the communication of offer will be there in the perspective of offering. Thereafter, we have communication of acceptance in both point of views, from the point of view of offerer, from the point of view of offeree or acceptor. So this depicts that communication, the origin of communication of offer starts from offerer. So there is nothing called as completion in case of offerer. There is a possibility of completion of offer in case of offeree. There is a possibility of completion of acceptance from the point of view of offerer and from the point of view of offeree. With an example, we'll understand it more detail. Let us say there is an event. There are sequence of events happened from 1st October to 25th October. 1st October, F, offerer, posted his letter to P, the acceptor or offeree. 5th October, P received the letter. 10th October, P opened the letter and read the letter. 15th October, P posted his acceptance to F. 20th October, F received the letter. 25th October, F opened and read the letter. So the communication of offer will be completed only when the other person gets the knowledge of that offer. So here in this case, let us see, F posted the letter to P. Did P receive the letter? P have not received the letter till 4th of October. He received on 5th of October. So till 4th, the offer was not communicated. On 5th, he received the letter. Does the offer communicated to P? Even at this scenario also, the offer was not communicated. P opened the letter and read the letter on 10th of October. Till 9th, the offer was not communicated. When the offer got communicated? Only on 10th of October. So the communication of offer is completed on 10th of October. Although it was sent on 1st, it was received on 5th. He read the letter. He opened and read the letter on 10th of October. So communication of offer is completed on 10th of October. Just we'll understand from, let us say, the real-time contracts. Example, you visited one shop. They offered you some products. You accepted the products. You paid money. They gave you product. So it's a real-time, instantaneous offer and acceptance. Let us say you made a mail. You made a call. All these are instantaneous offer and acceptance. Only in case of letters, as the act is from 1872, the Contract Act is 1872, and most of the time the communication used to happen through letters. So these are the things, conditions we need to remember in case of communication of offer. So the communication of offer got completed on 10th of October. This is with regard to offer. Let us talk about acceptance. So 15th October, P posted his acceptance to F. 15th October, P posted his acceptance to F. So the moment P posted his acceptance to F, P does not have control over that letter. P does not have control over that letter. So the moment it got posted, the moment it is out of control of P, then we say the communication of acceptance is completed from F point of view, from the offerer point of view. So F received the letter on 20th and F opened and read the letter. The moment F read the letter, then we'll say the communication of acceptance got completed from P point of view. From P point of view. So the F is offerer, P is offering. So let us recall. The 1st October, F posted the letter. Offerer posted the letter to offeree. 5th October, offeree received the letter. 10th October, offeree opened and read the letter. The moment he read the letter, he knows about the offer. So communication of offer is completed on 10th of October. Pretty much clear, no doubt at all. So now we'll move to communication of acceptance from the point of view of offerer, from the point of view of offeree. So 15th October, P, offeree, posted his acceptance to F. So now offeree, Mr. P, the letter is out of control of Mr. P. The letter is out of control of Mr. P. So the moment it got posted, that is the time where communication of acceptance is completed from the point of view of Mr. F, offerer. Then F received the letter on 20th and F opened and read the letter on 25th. So once he read the letter, then we say communication of acceptance is completed from offeree's point of view, which is F's point of view, Mr. F's point of view. Hope it is clear. So these are the things. You can take a screenshot, you can refer it back. So we'll move to communication of offer and acceptance. We discussed timings. Now we are going to discuss modes, performance, and special conditions. So how you can communicate offer and acceptance? So it can be by way of act. Act means express or implied. Express or implied, which is verbal and written, and actions and conduct of parties. Through omission as well. Sometimes through omission as well. As we have discussed, act or abstinence of doing. To do or abstinence of doing. So omission consists of abstinence of doing or not to do something. Then we have performance. In case of performance, Carlyle versus Carbolic Smoke Ball Company. So the communication of performance, at times you need to communicate, at times communication of performance is no need. In Carlyle versus Carbolic Smoke Ball Company, the communication of performance is of no need. So Carlyle, she took the inhaler, she took the smoke ball and she attracted influenza, or her influenza got not reduced. Hence, she claimed it. She claimed the money, she claimed the offer of 100 euros. She got that money. She won the case. So, Carbolic Smoke Ball Company cannot ask for whether Carlyle, she used smoke ball or not. Because the conditions, there were no conditions mentioned that the performance has to be communicated to Carbolic Smoke Ball Company. Here, communication of performance need not to be explained, need not to be given to Carbolic Smoke Ball Company as it was not mentioned. And there are special conditions, which is Raipur Transport Company versus Ghanshyam. So in this case, Ghanshyam was dealing with goods transport. Raipur Transport Company is doing logistic business. So the goods which were happened to be dispatched through Raipur Transport Company. So the conditions, special conditions were newly introduced and it was communicated to Ghanshyam later period. So the moment offer and acceptance happened, at that point in time only you need to finalize the conditions. We discussed acceptance must be absolute and unqualified, unconditional. So post agreement, post contract, you cannot get new conditions. Those conditions will not be valid for the contract which you have entered in past. So that is the case law about Raipur Transport Company versus Ghanshyam. Thereafter, we'll discuss about revocation. We are done with communication. We'll discuss revocation of offer and acceptance. In case of revocation, it is from, for the offer as well as for the acceptance, it is from both point of views. So you can remember like this. With an example, we'll understand this in much more clarity. So in case of revocation, we need to also see the definition. In terms of section 4, communication of revocation is complete as against the person who makes it when it is put into a course of transmission to the person to whom it is made so as to be out of the power of the person who makes it, as against the person to whom it is made when it comes to his knowledge. To clarify it, if A, example, A has A wants to revoke the offer with B. So A has posted the letter. The moment A posts the letter, and which is of no control of A, then we say revocation, communication of revocation is complete from the perspective of A, from the perspective of offerer. The moment it reaches to B, then we say communication of revocation get completed from point of view of B. Hope it is clear. As again as the person who makes it, let us say A, the communication of revocation is completed with perspective of A when it is put into course of transmission. He posted the letter. So from the point of view of A, revocation's communication is completed. The moment B opened up and read the letter of revocation, the communication of revocation gets completed from the point of view of B as well. Hope it is clear. We'll see few more examples to get more clarity. So we have discussed this in our previous example of communication of acceptance, communication of offer. So now we are discussing about revocation. So the revocation, let us say in the same example, let us talk about revocation of offer. Revocation of offer. So revocation of offer. So on day 1, on 1st October, the offer was communicated? No. 5th October, the offer was communicated? No. It is not even an offer. We are talking about revocation of offer. 10th October, will it be constituted as an offer? Yes. So 10th October, the offer got communicated. Now, when P posted his acceptance on 15th. So can we revoke on 11th? Can we revoke on 12th? Can we revoke on 14th? Yes. We can revoke from 11th or we can revoke on 10th, 11th, 12th, 13th and 14th. But we cannot revoke it on 15th because the moment 15th P posted his acceptance to F, communication of acceptance is completed from F point of view. So from F point of view, the communication got completed. So it becomes an agreement. It becomes a contract from F point of view. So it is no more an offer on 15th October. It is a contract in F point of view, and it will be a contract from P's point of view on 25th of October. So from 10th till 14th, revocation can take place of revocation of offer. So 12th October, F called and informed about revocation. So revocation of offer, we are taking scenario 1 through call. So F called and informed about revocation on 12th. So does P posted his acceptance? Till 12th, he has not posted his acceptance. So it was still an offer. It was still an offer. Just offer was communicated. It was not become a contract. So till 14th also, it was not became a contract. So on 12th, on 13th, on 11th, and on 14th, F can make a call and informed about revocation, and revocation of offer is completed instantly for both F and P because it's a call. It's a telecall. So it got instantaneously informed and got communicated at same point in time. So revocation of offer from both perspective, it got completed. If it is through post, let us see the scenario. Let us say if it is through post. So 11th, F sends a letter to P. Then the moment he sends the letter, once it is out of transmission, once it is no more control of F, then revocation of offer is completed from F point of view, which is offerer's point of view. 14th, he received and read the letter. Then we call it as he came the knowledge about the revocation. Then we say revocation of offer is completed from P's point of view as well. So from F point of view, when we kept the letter out of transmission, out of control of F, then we say it is completed. The revocation of offer is completed from F point of view. P received the letter on 14th. So revocation of his offer also completed from P's point of view. So these are the two scenarios. One is through call, one is through post. And these two examples are talking about revocation of offer. We will also discuss about revocation of acceptance. So before going to revocation of acceptance, we'll understand the difference between English law and Indian law with respect to revocation of acceptance. When it comes to revocation of offer, the English law and the Indian law is one and the same. There is no difference at all. But in case of revocation of acceptance, it is different. How it is different? In case of English law, the moment person accepts, the moment person provides his acceptance, it becomes contract and you cannot revoke it. It is irrevocable. You cannot revoke it. It is irrevocable. In case of Indian law, the position is different as regards contract through post, which we will see in the following examples. So you remember this. In case of English law, the moment acceptance is provided, it is irrevocable. You cannot revoke it. In case of Indian law, the position is slightly different. We'll see that. So this is the same example which we have taken for communication of offer, communication of acceptance, revocation of offer. We'll also take it for revocation of acceptance. Just to revise it, 10th October, offer got communicated. 15th October, acceptance was sent to F. So from the point of view of F, the acceptance got communicated. But from the point of view of P, acceptance still not communicated. So let us say the scenario 1 through call. 18th October, P called F and informed about revocation of acceptance. So P called F. The offeree calls offerer and informed about revocation of acceptance. So the revocation of acceptance is completed instantly for both P and F. So let us say from English law point of view, 15th October, the communication of acceptance got completed. It is not irrevocable. You cannot revoke it. So that is English law. Whereas Indian Contract Act 1872 gives certain leeway. So 18th October, because F has not opened and read the letter, he read the letter on 25th October. Till 18th October, till 24th October, you can do revocation. That is the difference between English law and Indian law. English law, 15th October itself, it is irrevocable. Whereas Indian law provides you to revoke the acceptance till 24th of October. So in case of a call, in this scenario, 18th October, P called F and informed about revocation of acceptance. He can revoke the acceptance. Scenario 2, through call on 24th. Can he make call on 24th and do it? Yes, he can do it and revocation gets completed. Let us say through post. This is the third scenario, through post. So 15th October, P posted his acceptance. 18th October, he posted his revocation. So 22nd, he received and 24th, he opened and read the letter before he read the letter of acceptance. So still revocation is completed. If he opened the letter on 26th, if the letter reaches on 26th, then the revocation is not possible. Hence, hope you understood the revocation of acceptance as well. Then we will also see the modes of revocation. How one can revoke in case of offer by offerer through communication, through call, through letters, through email, etc. Revocation of acceptance by offeree. So through communication, similarly calls, mails, letters, etc. Counter offer. Let us say offeree gives a counter offer or a conditional acceptance. Then we say the original offer is cancelled. Non-acceptance. He kept silent. He kept silent. Non-fulfillment of conditions. As we have discussed, it is prescribed mode and specified time. You should submit your acceptance within certain time. You should submit your acceptance in prescribed mode. You need to attach blank checks. You need to attach demand draft. You need to give a check. All these examples, and you need to make this acceptance within specified time. If you does not fulfill any of the conditions mentioned, then the acceptance gets revoked. In case of, there are certain modes of revocation with regard to environment. Example, illegal. suddenly the offer or the objects activities involved in this offer or acceptance become illegal, subsequently became illegal. Lapse of time, because of lapse of time. So you have, although it is an offer which was not time bound, but there is something called as reasonableness. There is something called as within 1 month, within 1 week, within 10 days, you need to provide your acceptance. It cannot be infinity, it cannot be limitless, it cannot be open ended forever. So there is reasonable time, even though the time limit is not mentioned, you should consider into a reasonable time to provide your acceptance to offerer. Next, any death of offerer or offeree, insanity of offerer or offeree makes the person becomes unsound mind, then it's not a valid thing. The offer or the acceptance get revoked in this case through, in case of environment. Hope this is clear. So with this, we are done with unit 1 of chapter 1, which is nature of contracts. So quickly, you need to recall the 5 subtopics of unit 1 of chapter 2, which is history, then definitions, then contract, then you have offer, then you have acceptance, and 2 other topics which are relating to both offer and acceptance, which is communication and revocation. Thank you.